Maxima shorthand classes. Get ready. 5 seconds. Criminal miscellaneous petition number 1296 of 2010 seeking impleadment as a party is dismissed. 2. This appeal is preferred against order passed by the High Court of Calcutta in CRR number 188 of 2005 in FIR number 21 dated 10th November 2004 on the file of Bada Bazar Police Station registered for the alleged offences under section 420 and 120B Indian Penal Code, including the order dated 28th October 2004 in case number C99 of 2004 passed by the Additional Metropolitan Magistrate Calcutta. 3. Briefly, the facts are as follows. The appellant herein, complainant, was looking for a plot of land for construction of residential house in January 2004, and accused number 2, Prasad Babu, a public servant, represented that he could arrange for the said plot and introduced the appellant to respondent number 1, accused number 1, who stated that he had a plot of land, and the appellant, believing the representation made by the accused number 2, entered into an agreement for sale. Respondent number 1 herein bar accused number 1 and also paid a sum of rupees 5 lakhs 1 rupee in cash. The respondent number 1 herein refused to hand over the necessary title documents to the appellant, which led to issuance of legal notice by the appellant. All other methods to compel respondent number 1 to complete the sale having failed, the appellant filed a complaint on 28th October 2004 in the Court of Additional Chief Metropolitan Magistrate Calcutta against respondent number 1 herein bar accused number 1 and accused number 2 for the offences punishable under section 420 read with section 120B of the IPC. The Additional Chief Metropolitan Magistrate forwarded the complaint to the officer in charge of the Bada Bazar Police Station for causing investigation under section 156(3) of Criminal Procedure Code by treating the complaint as first information report. Respondent number 1 herein bar accused number 1 filed application under section 482 of CRPC for quashing the said proceedings, including the FIR. And herein bar complainant was pleaded as a party. No attempt was made to serve notice on him, with the result that the learned single judge of the High Court quashed the complaint proceedings in the absence of the appellant herein. Challenging the said order, the appellant herein preferred appeal to this court in criminal appeal number 82 of 2007 by judgment dated May 9th, 2007, allowed the appeal and remitted the case to the High Court for a fresh decision in accordance with the law. Therefore, the High Court heard both the parties and by impugned order dated June 29, 2009, allowed the application under section 482 CRPC and quashed the complaint proceedings. Aggrieved by the same, the complainant has preferred the present appeal. 4. The Land Council for the appellant contended that the contents of the complaint would disclose the commission of the cognizable offences alleged, and the High Court at the preliminary stage would not be justified in embarking upon an inquiry and quashing the proceedings, and hence the impugned order is liable to be set aside. Per contra, the learned counsel for the respondent number 1 bar accused number 1 contended that the dispute involved in the complaint is of civil nature and none of the acts allegedly committed by the respondent number 1 gave rise to any criminal liability as rightly held by the High Court. In support of the submission, he relied on the following decisions of this court in Rajan Verma and others versus State of Bihar and another. 5. The legal position with regard to exercise of jurisdiction by the High Court for quashing the first information report is now well settled. It is not necessary for us to delve deep thereinto, as the propositions of law have been stated by this court in Kalyani versus Janaki within brackets 2009 in the following terms. 15. Propositions of law emerge from the said decisions are 1. The High Court ordinarily would not exercise its inherent jurisdiction to quash a criminal proceeding and, in particular, a first information report, unless the allegations contained therein, even if given face value and taken to be correct in their entirety, disclosed no cognizable offence. 2. For the said purpose, the court, save and except in very exceptional circumstances, would not look to any document relied upon by the defence. 3. Such a power should be exercised very sparingly. If the allegations made in the FIR disclose commission of an offence, the court shall not go beyond the same and pass an order in favour of the accused to hold absence of any mens or actus reus. 4. If the allegation discloses a civil dispute, the same by itself may not be a ground to hold that the criminal proceedings should not be allowed to continue. 6. Yet again, in Mahesh Chandra versus State of Rajasthan within brackets 2008, this court stated the laws thus. 11. The principle providing for exercise of the power by a High Court under section 482 of the Code of Criminal Procedure to quash a criminal proceeding is well known. The court shall ordinarily exercise the said jurisdiction inter alia in the event the allegations contained in the FIR or the complaint petition, even if on face value are taken to be correct in their entirety, does not disclose commission of an offence. 7. In the present case, the complaint does make averments so as to infer fraudulent or dishonest inducement having been made by respondent number 1 herein and accused number 2, pursuant to which the appellant parted with money. It is the case of the appellant that respondent number 2 doesn't have title over the property, since the settlement deed was not a registered one, and respondent number 1 herein and accused number 2 had entered into criminal conspiracy, and they fraudulently induced the appellant to deliver a sum of rupees 5 lakhs 1 rupee with no intention. The averments in the complaint would prima facie make out a case for investigation by the authority. 8. In the decisions relied on by the learned counsel for the respondent number 1 cited supra, this court, on the facts therein, held that the allegations in the complaint read as a whole prima facie did not disclose commission of offences alleged and quashed the criminal proceedings. Those decisions do not apply to the fact situation of the present case. 9. The High Court has adopted a strictly hyper-technical approach, and such an endeavour may be justified during a trial, but certainly not during the stage of investigation. At any rate, it is too premature a stage for the High Court to step in and stall the investigation by declaring that it is a civil transaction wherein no semblance of criminal offence is involved. 10. The appellant is therefore right in contending that the first information report should not have been quashed in this case and the investigation should have been allowed to proceed. 11. We therefore allow this appeal and set aside the impugned order.